just days after a Supreme Court ruling that could shield presidents from criminal charges for official acts. Trump's legal team is making waves to halt his classified records case in Florida. And wait until you hear about Justice Clarence Thomas's opinion. It might challenge the very legitimacy of Special Counsel Jack Smith's appointment. What does this game-changing twist mean for Trump's case and his future? Welcome back to the channel. Donald Trump needs to stop his grouped records case in Florida for a very long time so he can contend that his charges ought to be tossed out under the High Court's new decision on official resistance. The previous president's lawyers likewise highlighted an assessment from Equity Clarence Thomas, who seemed to concur with Trump's contention that extraordinary guidance Jack Smith was illegally delegated and financed, a case at the focal point of Trump's endeavors to have the case excused. Friday's filings in the Blemisher-Lago case showed up only days after the High Court proclaimed that no president can be criminally arraigned for any official act in the chief office, possible conceding the previous president some security in his government political decision impedance case. Trump presently needs the adjudicator in his grouped reports case to hear contentions that he ought to be safe from those charges sooner or later among now and September, which would successfully crush the remainder of Florida procedures to an end, while they banter whether the High Court's decision applies. Trump's lawyers independently contended that Thomas's contention adds force to Best's case, that Smith's arrangement and financing is unlawful and raises grave partition of abilities concerns. Thomas composed his own different agreeing assessment in the resistance choice to explicitly target the unique directions office, days after Trump's lawyers posed similar viewpoints to pass judgment on Aileen Cannon in Florida. The moderate equity ventured to such an extreme as to say that the government judge regulating Trump's political race impedance case ought to reevaluate whether Jack Smith was even legitimately named to the gig, giving Trump and the adjudicator managing Trump's arranged documents case more lawful ammo in support of himself. The stunning choice on resistance from the country's High Court has previously been utilized to scramble Trump's condemning in New York, where a jury in May sentenced him on every one of the 34 counts of distorting business records. This week, Equity Juan Merchant consented to defer his condemning date by 2 months, giving Trump's lawyers time to attempt to present their defense that the decision ought to be voided. That case unequivocally manages Trump's confidential activities to a great extent before he went into the White House, yet some proof from investigators, including discussions at the White House and declaration about his activities as president, could be forbidden, as indicated by his lawyers. Trump was booked to be condemned on July 11th. After the resistance choice and supplications from Trump's lawful group, Judge Merchant deferred the condemning date to September 18th. Trump has to deal with 40 separate penalties originating from claims that he kept many characterized reports in the wake of going out for his confidential Blemisher-Lago compound in Florida, then plotted to block government endeavors to recover them. He has argued not liable. Stay tuned for more updates on this developing story, and thanks for watching Global TV 2.0.